Welcome to our Legal English for Lawyers. And today we are exploring the invisible architecture of our daily interactions. So, as you can see, the law of contracts. So, from simple retail purchases to complex corporate mergers. Contracts define our rights and protect our interests. In this presentation, we'll break down exactly what constitutes a binding agreement, the essential elements required for legality, and the remedies available when those priorities are broken. So let's get started. What is a contract? Let's break down this phrase. An enforceable agreement. That is, a contract is an agreement that creates a binding obligation. Please pay particular attention for the phrases and expressions that I have highlighted for you. That's the legal English. Upon the parties involved, it is the foundation of legal relationships in both personal and business spheres. Next, we need to delve into of essentials of a contract. So, we do have core requirements, three core requirements, that is mutual agreement, legal consideration, and legal capacity. So let's get started with the mutual agreement, a meeting of the minds where all parties agree to the same terms and the same conditions. The next is the legal consideration, that is something of value exchanged. Please note that in most instances, this need not be financial. And the last one is legal capacity, which parties must be of sound mind and legal age to make a binding commitment. Now, let's delve into an integrity and legality. First is absence of fraud. What is that? That is the agreement which must be made without deception, fraud, or duress, that is coercion. And the next one is legal subject matter. That is, the purpose of the contract must not be illegal or against public policy. Next, one question arises here. What form does a contract take? Medium of agreement. So we do have oral contracts and written contracts. Two differs. Oral contracts in general, that is, contracts may be only oral. Verbal agreements can be legally binding, though harder to prove in court. The next is written contracts. That is, while many agreements are oral, formalizing terms in writing provides clarity and essential evidence of intent. Next is mandatory writing. That is, certain types of contracts must be written and signed to be enforceable. Property transactions. That is, this includes any contract involving the sale and transfer of property. Next, the question arises, how does a contract end? So how we need to complete our contract. Breach of contract. If a party fails to fulfill their obligations, that is a breach. The injured party may seek financial compensation, that is damages, rescission, canceling the contract, and injunction, stopping a specific action. So, specific performance. A right by one contracting party to have the other party perform the contract according to the precise terms agreed, applied when financial compensation would not suffice. And here, contracts are central to the legal relationships between individuals and companies. So, binding, mutual, and enforceable. So, that's all for this very short session. And if you find my lectures helpful and valuable, I want you to stay updated on more legal essentials. Please subscribe to my YouTube channel and follow me on Instagram and Telegram for daily and weekly insights and tips. And thanks for watching my lessons, and I'm happy to answer any questions you may have regarding these legal principles as well.